Hi, my name is Dr. Debarati Halder and I am the Managing Director Honorary for Center for Cyber Victim Counseling. In this video, I am going to discuss about court system under Information Technology Act 2000 amended in 2008. Information Technology Act 2000 amended in 2008 indicates that there are two types of issues that can be dealt with under the IT Act, that is civil and criminal. As such, there are two types of tribunals or courts who may handle cases in the nature of civil and criminal liabilities. Let us now discuss about administrative tribunals, courts, etc. for civil liability cases. As can be seen from this flowchart, it contains High Court, Cyber Appellate Authority or Telecom Dispute Settlement and Appellate Tribunal, Controller, Adjudicator, Deputy or Assistant Controllers, and Certifying Authorities. Let us discuss this in an elaborate manner. The administrative tribunal system under the IT Act has three tiers. At the grassroots level is the certifying authorities. A licensed certifying authority or CA who has been granted license under Section 24 issues the digital signature certificates. Certifying authorities are controlled by controllers. Controller is appointed by central government under Section 17 of the Act. The same section also mentions about the appointment of deputy or assistant controllers who should work under the instruction of the controller. Let us now discuss about the functions of the controller. This is discussed under Section 18. It includes exercising supervision over the activities of the certifying authorities, certifying public keys of the certifying authorities, laying down the standards to be maintained by the certifying authorities, specifying the qualifications and experience which employees of the certifying authority should possess, specifying the conditions subject to which the certifying authorities shall conduct their business, specifying the contents of written, printed, or visual materials and advertisements that may be distributed or used in respect of an electronic signature certificate and the public key, specifying the form and content of Section 27, that is electronic signature certificate and the key, specifying the form and manner in which accounts shall be maintained by the certifying authority, specifying the terms and conditions subject to which auditors may be appointed and remuneration to be paid to them. Facilitating the establishment of any electronic system by a certifying authority either solely or jointly with other certifying authorities and regulation of such systems, specifying the manner in which the certifying authorities shall conduct their dealing with the subscribers, resolving any conflict of interest between the certifying authority and the subscribers, laying down the duties of certifying authorities, maintaining a database containing the disclosure of a record of every certifying authority containing such particulars as may be specified by regulations, which shall be accessible to Let us now discuss about the other functions and responsibilities of the controller. Controller may also recognize the foreign certifying authorities with prior approval from the government under Section 19. Controller may suspend license under Section 25. Controller has power to investigate contraventions or authorize any officer to do the same under Section 28. Controller may also access to computer and data under Section 29 if he has reasonable cause to suspect for any contravention of the dispute resolution functions of the controller includes resolving any conflict of interests between the certifying authorities and the subscribers. Tier or the second person is the adjudicator. Section 46 provides for the post of adjudicator for the purpose of adjudicating under Chapter 9. Adjudicating officers are appointed by the central government. Such officer should not be below the rank of a director to the Government of India or an equivalent officer of a state government. No person shall be appointed as an adjudicating officer unless he possesses such experience in the field of information technology and legal or judicial experience as may be prescribed by the central government. Let us now discuss about the purpose of adjudging as has been discussed under Section 46(1). Adjudicating officers are appointed for holding an inquiry in the manner prescribed by the central government in cases where any person has committed a contravention of any of the provisions of this Act or of any rule, regulation, direction, or order made thereunder, which renders him liable to pay penalty or compensation. The jurisdiction of the adjudicating officers is also discussed under Section 46, which says the adjudicating officer appointed under Section 46(1) shall exercise jurisdiction to adjudicate matters in which claim for inquiry or damage does not exceed Rs 5 crore. However, if the jurisdiction in respect of claim for injury or damage exceeds Rs 5 crore, it shall vest with the competent court. Let us now discuss about the power of the adjudicator. Every adjudicating officer shall have the power of a civil court which are conferred on the Cyber Appellate Tribunal under subsection 2 of section 58. All proceedings before the adjudicator shall be deemed to be judicial proceeding within the meaning of section 193 and 228 of the Indian Penal Code, shall be deemed to be a civil court for the purposes of sections 345 and 346 of the Code of Criminal Procedure 1973, shall be deemed to be of a civil court for the purpose of Order 21 of the Civil Procedure Code 1908. The other powers of the adjudicators include Section 47, which says, while adjudging the quantum of compensation under Chapter 9, the adjudicating officer shall have the due regard to the following three factors, namely, the amount of gain of unfair advantage wherever quantifiable made as a result of the default, the amount of loss caused to any person as a result of the default, the repetitive nature of the default. At the top layer of the administrative tribunal and the court system for civil cases is the Cyber Appellate Tribunal or Telecom Disputes Settlement and Appellate Tribunal. Section 48 of the Information Technology Act 2000, amended in 2008, stated that the central government shall, by notification, establish one or more appellate tribunals to be known as Cyber Appellate Tribunals. However, since 2017, the Telecom Disputes Settlement and Appellate Tribunal, that is TDSAT, established under Section 14 of the Telecom Regulatory Authority of India Act 1997, that is TRI Act, has substituted CAT and working as Appellate Tribunal for the purpose of IT Act. TDSAT exercises the jurisdiction, powers and authority conferred on it by or under IT Act. Constitution of the Tribunal. As can be seen, it has got chairperson and 2 members. The authority can consist of a chairperson and not more than 2 to be appointed by the central government. Qualification for the members of the tribunal. First, we need to understand about the earlier understanding. Chairperson of the tribunal had to be a judge of the High Court as per Section 50 of the IT Act. The present regulation as per Section 4 of the TRI Act says the chairperson and other members of the authority shall be appointed by the central government. The desired qualifications are special knowledge of and professional experience in telecommunication, industry, finance, accountancy, law, management or consumer affairs. A person who is or has been in the service of the government shall not be appointed as a member unless such person has held the post of secretary or additional secretary or the post of additional secretary and secretary to the Government of India or any equivalent post in the central government or the state government for a period of not less than 3 years. Jurisdiction and limitations of the appellate authority. Any person aggrieved by an order made by the controller or an adjudicating officer under this Act may prefer an appeal to the appellate tribunal having jurisdiction in the matter. No appeal shall lie to the appellate tribunal from an order made by an adjudicating officer with the consent of the parties. Every appeal under subsection 1 shall be filed within a period of 45 days from the date on which a copy of the order made by the controller or the adjudicating officer is received by the person aggrieved, and it shall be in such form and be accompanied by such fee as may be prescribed. Appellate tribunal may entertain an appeal after the expiry of the said period of 45 days only if it is satisfied that there was sufficient cause for not filing it within that period. Court for dispute resolution of criminal nature. Information Technology Act 2000, amended in 2008, does not specifically mention about any court which may handle cases of criminal nature under this Act, but we can definitely look into Section 77A of the IT Act, which speaks about compounding of the offences. According to this provision, a court of competent jurisdiction may compound offences other than offences for which the punishment for life or imprisonment for a term exceeding 3 years has been provided under this Act. The court shall not compound such offence where the accused is, by reason of his previous conviction, liable to either enhanced punishment or to a punishment of a different kind. The court shall not compound any offence where such offence affects the socio-economic conditions of the country or has been committed against a child below the age of 18 years or a woman. Section 77A, subsection 2 of the IT Act states that a person accused of an offence under this Act may file an application for compounding in the court in which offence is pending for trial, and the provisions of Section 265B and 265C of the Code of Criminal Procedure 1973 shall. What can be inferred from here? Any competent court under CRPC which are competent to handle cases involving offences and punishments as has been prescribed under Chapter 11 and also other chapters may be considered as competent court for the purpose of this. Now, let us understand which criminal courts may handle cases of criminal nature under IT Act. For this, we have to understand the patterns of punishments under Chapter 9 of the IT Act. There are several punishments or imprisonment sentences under IT Act. For example, imprisonment for a term which may extend to 2 years or with fine which may extend to 1 lakh rupees or with both. Imprisonment of either description for a term which may extend to 3 years or with fine which may extend to rupees 1 lakh or both. Imprisonment of either description for a term which may extend to 3 years and shall also be liable to fine which may extend to rupees 1 lakh. Imprisonment which may extend to 3 years or with fine not exceeding 2 lakhs rupees or with both. Imprisonment up to 3 years or with fine which may extend to 2 lakhs rupees or with both. Imprisonment for a term which may extend to 3 years or with fine which may extend to 5 lakhs rupees or with both. Imprisonment extending to imprisonment for life. Imprisonment in first conviction of either description for a term which may extend to 3 years and with fine which may extend to 5 lakhs rupees, and in the event of second or subsequent conviction with imprisonment of either description for a term which may extend to 5 years and also with fine which may extend to 10 lakh rupees. On first conviction with imprisonment of either description for a term which may extend to 5 years and with fine which may extend to 10 lakh rupees, and in the event of second or subsequent conviction with imprisonment of either description for a term which may extend to 7 years and also fine which may extend to 10 lakhs rupees. Finally, life imprisonment. Now, let us understand the powers of various criminal courts under sections 28 and 29 of CRPC. Sessions and additional session judge can deal with any sentence authorized by law. In case of death sentence, it is subject to confirmation of the High Court. Assistant Sessions Judge can deal with any sentence of imprisonment up to 10 years and or fine. Chief Judicial Magistrate or CJM, Chief Metropolitan Magistrate can deal with any sentence for which imprisonment goes up to 7 years and or fine. Judicial Magistrate Class 1 and Metropolitan Magistrate can deal with any sentence, imprisonment for which goes up to 3 years and or fine up to 10,000 rupees. Judicial Magistrate Class 2 can deal with any sentence, imprisonment for which goes up to 1 year and or fine up to rupees 5,000. In other cases also, if it involves children or if it targets children, then the courts, as has been described under the Protection of Children from Sexual Harassment Act, that is POCSO Act, can also deal with such offences.